This is case number 06-125-000. This is Hirschberg Acceptance Corporation versus Eugene Young. The matter is before the court on the following objections to a writ of garnishment. The record should reflect in this matter that a judgment was entered by default in 2006 for $1,731. The record should further reflect that that judgment was renewed in September 2016 for $1,731. This is a garnishment in relationship to the Michigan Department of Treasury. I have received the objections to the writ of garnishment. Your appearance for Hirschberg Acceptance at this time, please. Anyone for Hirschberg Acceptance? Let me hear from Eugene Young. Mr. Young is on the Zoom. Say something at this time, sir.
Not guilty.
Well, I'm glad it's not a criminal case, but if it was, I'm glad you're not guilty in a criminal case. Just as a civil matter, you have a judgment that was issued against you, and the plaintiff has filed for a garnishment against your Michigan State, apparently income tax return, because that judgment has not been paid off. Your objections say that the funds are exempt, number one, and that the judgment is paid. Tell me about that, sir.
What it is when I was in school, I was in the military.
Let me stop you for a moment. Let me stop you for a moment. I don't need you to go back to that. You have a judgment against you that was entered in 2016. That judgment is still in place at this time. If you wish to try and find ways to get that judgment moved, you have to file certain motions to try and address the underlying judgment. Right now, the only thing that the court can address by court rule, the only thing I can address is the garnishment. So there's a garnishment against your income tax return. You stated two reasons. You said that you already paid this judgment. You also said funds are exempt. When did you pay the judgment off?
It was paid off in 80 when this Heisenberg, or what is it? Heisenberg Acceptance Corporation. They started this as I even have a federal court number, whereas they dismissed the case. And they this acceptance company, they bought the loan. They have taken and garnished my taxes like 3 different times. I have the paperwork here to substantiate all of that there, where this is their 4th time trying to get paperwork. I mean, to take my check. And they took one for 900 one year. They took another one for 500, and then they took another one for 4 something. And the loan, it was only $300 when it started out. And I have the paperwork on my promissory note from the school to substantiate that. And then the government gave up the loan, but they come back every 5 or 6 years with another attorney. And I don't know how they're digging up the cases or whatever, but I have all my paperwork to show this. And they steady going up on it. And it was thrown out of court because I had my paperwork to show, whereas I was exempt. I made my last payment. This would have been my last payment. And I have paperwork to that. And all I did was just sign the paperwork. And there was one that I did not sign. And I can't remember what happened or what I went to or whatever. But at the same time, they have collected this payment more than once, and the federal government isn't receiving any of this money. All this money that they has taken is going straight to them.
All right. So I've listened to you, and most of what you had to say, don't have anything to do with any of this. That's why I started out by telling you that a judgment was entered in 2006, and then another renewed judgment was entered in 2016. So the only thing that's relevant here is that judgment from 2016. So when is it? You said that you were garnished for $900. How long ago was that?
That was in the 90s.
Okay, when were you garnished for $500?
And then there was
When were you
a,
garnished? Let me stop you. You told me about the $900 garnishment. You said that was in the 90s. You said that you were garnished also for $500. How long ago was that, sir?
that was, hold on a minute. Let me go through this paperwork. I had it all laid out here.
Let me ask you this. Was it any time since 2006?
No, it was 2001.
That doesn't have any relevance to this case. What about the $400 you were talking about?
Then there was another one in 2000 or 2090 something. I don't know what year it was. I can't locate that paperwork. I have all the paperwork that this company, and there's been other companies that
Yeah,
has.
let me stop you. The only thing that's relevant in regard to this case is
Okay.
2006 and 2016, because that's 2016 is a judgment that we're dealing with now. If you could show me money that you paid since 2016, then I can certainly consider that in terms of assessing how much money might be owed. Let me ask you another question. You raised the specter that funds are exempt. What type of income do you have, sir?
I only received Social Security.
All right. And how long have you been receiving Social Security as your sole source of income?
Oh, wow.
You're not
I
sure?
don't know.
Okay. All right.
It's been a while.
It's been more than a year. Is that correct, sir?
Yes, yes.
All right. So this Michigan State Department of Treasury income tax type situation, did you win the lottery, or do you have some money that you're expecting back from the Department of Treasury?
I have money that I'm expected back from filing taxes.
All right. And how much are you anticipating from the state regarding your tax filing?
Let me see.
Now,
Could you
off the top, are you
off
expecting
the top about 1,200?
About 1,200. And how is it that you're getting $1,200 back? Is that a homestead or something?
No, that's me and my wife together.
Oh, is your wife together? Okay. So she
Yeah.
has something other than Social Security income. Is that correct?
Yes, she has that in pension.
All right, gotcha. All right, the court, under the circumstances presented before this court, the court will make a determination that there is indeed yet a judgment that remains in place. The court will further find under these circumstances, it certainly sounds like the funds are exempt. Now, any funds that might have been made available will be funds that relate to some other person that is a joint filer. That person would not be obligated under this indebtedness. Moreover, Mr. Young, based on his communication to the court, indicates that any income that he generates would be income in association with Social Security, and Social Security funds would be exempt from any garnishment. Therefore, the court will find that the objections are valid, and any funds held will be released to the defendant in this matter, and the garnishment be set aside. I do wish you well, sir. You'll receive a copy of my order releasing the garnishment in the mail. I wish you well, sir. Good day to you.
Thank you very much, Your Honor. Have a nice day.
Thank you, sir.
You won?
I won.
Did you? Was he black or white?
Black.
Was that Donald Coleman?
I don't know. I won.
Oh, you won. Thank you, Jesus.
I
So that
won.
should be over,
And
period.
that should be over, period.
Better
Them
know that.
motherfuckers ain't getting shit.
No, when you talk it now.
Excuse us. Tried to shut them up a little bit sooner, but anyway. All right, this is case number. But I will say that the entertainment is free this morning. You do not have to pay anything for it. This is case number 21-171326. This is Z Ride Home LLC versus City of Detroit. The matter is before the court set on for a adjourned pretrial conference date. Your appearance for Z-Ride this time.
Morning, Your Honor. John Betts for plaintiff Z-Ride. My P number is 24468.
Thank you, Mr. Betts, and good morning to you, sir. For the city of Detroit, if you will, at this time, your appearance, please.
Good morning, Your Honor. Ben Patterson on behalf of the city of Detroit, P number 85118.
All right, thank you, Mr. Patterson. Good morning to you as well. I know I previously set forth a scheduling order that is to end up today as it relates to the discovery issue. What is the status of things at this point? Gentlemen, somebody.
Your Honor, if I may, this is a transportation bill for a lady named Shaniqua Hentz. Ms. Hentz has her own Wayne Circuit suit pending against the city of Detroit, and an issue has arisen in that case whereby there's the possibility that she had insurance coverage with National General Insurance Company. Mr. Patterson, that represents the city, stipulated to the addition of National General to our case, and I mailed in a proposed stipulated order on May 5th, asking the court to enter it. So we have, I guess, a priority dispute. Who is responsible to pay no-fault benefits, the city of Detroit or National General Insurance Company? So I'm asking the court to enter that stipulated order adding National General.
And Your Honor, from reviewing the register of actions, I believe the court has already entered the stipulation. I think it may have been this week. So I think the next action would be plaintiff amending its complaint to add National General as a defendant. There is resident relative insurance for the underlying claimant. So National General should be first in priority.
All right, very well. So I do remember, I'm looking for it in the file, but I remember signing that order. And it's getting pretty interesting when I'm starting to remember among all of the files that I have. I remember signing the order adding the additional party with regard to this matter. So I know that have you already signed off, have you already commenced trying to do some service there, or is that other party accepting service regarding this matter, or do you know yet? Mr. Betts.
I'm sorry, Your Honor, I didn't catch what you said.
Just asking about the status of the additional or the added party. Have they been served? Are they stipulating to the jurisdiction of the court, or nothing's been done in that regard yet?
My thought is I have not received the order adding National General signed by you. When I do receive it, I'll file an amended complaint, get in a amended summons issued, serve National General to bring them into the suit. But I can't do that, I don't think, unless I receive a copy of the order signed by the court.
All right, yeah, I got it. I guess what my inquiry was whether or not the parties had either mutually or otherwise reached out to that other party to see if they were stipulating. But I got you. I've already prepared the order. It should be on its way, Mr. Betts. So I'm going to go ahead and continue discovery order in this matter over the next 45 days, and I'll have you come back post that time. All of those other ends should be tightened up by then. So we're going to bring this matter back in July. That's going to be, actually, it's going to have to be July the 21st, 7/21, 22. The court has already granted the order allowing the addition of the party that we spoke of, and I'll set this matter over for 9:45 p.m. on 7/21. And you will get a notice. You'll get a notice of the same. And I'm continuing the scheduling order with regard to discovery through that date as well. All right, and so good day to you, gentlemen. I'll see you at the next action.
Thank you, Your Honor.
Thank you.
court now calls case number 20-144287. This is Portfolio Recovery Associates LLC versus Tiffany Marshall. The matter is before the court on the following of objections to a writ of garnishment. The record should reflect that a judgment was entered in this matter. Just one moment, I have that. On the 27th of October 2020, the judgment amount is $934.01. The court received the objections indicating, I should indicate that this garnishment relates to the Michigan Department of Treasury. I received objections to the writ of garnishment. No category has been checked as to why there are objections in this matter. Your appearance for portfolio, please.
Yes, good morning, Your Honor. Michael Kirshenheiter for the plaintiff, P75722. How are you?
I'm fine, sir. Good morning to you. I'm looking now for Ms. Tiffany Marshall. If you want to soon say something at this time.
Hi.
All right, good morning. Good morning, Ms. Marshall. I do see you there, ma'am. And I see your objections to the writ of garnishment, but you didn't give any reason as to why, any basis for your objection. Tell me why you're objecting in regard to this matter, ma'am.
Yes, the reason for my objection was that I paid the garnishment on April the 7th, 2021, the full balance of $934.01.
All right. Counsel?
Yeah, we haven't received any payment like that. The only payment we received, we have actually received the tax garnishment funds, but we did not receive any other payment. So I'm not sure who she paid it to, where she paid it, if she made the payment, but we haven't received that payment.
All right.
Yep, I have the receipt for Weber and Aussie that I sent it to, and I spoke to one of their representatives.
I'm looking at a document that says it looks like it's from Weber and Osisa. You submitted to me. You didn't check off any box. You know you have to do that, otherwise you run into other kinds of problems, Ms. Marshall. But I'm looking at your document that you submitted. It says our client Portfolio Recovery Associates LLC has authorized us to offer you a lump sum settlement of $653.81 on the above account. There's a savings of $280. And then I see your check payment has been received by Weber and Olise, PRA Lotta 15. Below is your receipt, and it has a receipted amount of $934.91. That's dated April the 7th, 2021.
Yes.
And the problem, I think, well, just one moment here.
No. Your Honor, are you saying this is a letter you're saying from my office? I don't.
This is a letter from Weber and Osise, and this and the reason that I'm looking carefully at it because they indicate their file number on that particular matter is 1943780. Now, Counsel, do you have any connection to Osise?
Yes, I'm from Weber and Osise's office. Our file number is 1943780. I have no record of any letter. I see no payment in our office. I don't see a conversation with Miss Marshall. So I'm a little taken aback. I don't know what's going on. Is that a letter that was attached to her objection? I didn't, we didn't get that. So.
Right. It's a letter that is attached to her objection, and the letter makes reference to an amount received, and it makes reference to April the 7th.
Yeah, I have nothing in my system showing we received a payment. I don't have anything in my system showing we sent her a letter. I just checked my system showing that to see if there might be another file for her. I didn't see another file for her. So I don't know. Like I said, I don't have the letter in front of me. I don't know if what's going on.
Right. And I'm noting the case number in three areas. So it's throughout the documents, and this is related back to 2021.
Yeah. So this was in April 2021. She paid this. So she's saying she paid this. All right. Let me go back a little further. Oh, Your Honor, I got it. I was in the wrong year. So she did make a payment to pay the judgment. The payment was unable to be located, so it never went through. So unless she could provide some sort of bank statement showing she made the payment, what happens generally is when it comes back unable to locate, it means a number was pushed in wrong normally. But that money did not clear our system. So that's why it was not clear.
All right, so the receipt that shows that you're looking at $934.01. Is that correct, sir?
That is correct.
Right, and it shows an account number that was that payment was connected to. Is that correct? Ending in 8799.
That is everything you've said. Now that I'm looking at the right month, everything you've said makes sense. When she made the payment, she would have received a receipt. We would have sent her a letter saying she made the payment. But then a few days later, the payment came back and it couldn't be processed.
All right, Ms. Marshall, tell me
Yes.
about the issue. The payment was never processed.
So I do have the receipt saying that it was processed and the payment never came back the full amount. And you mentioned the settlement. I received that settlement and I didn't pay the settlement. I paid the full balance. Nothing came back. And I have all of the receipts here that are attached to the paperwork that I sent in, but nothing came back on my end. And anytime I tried to reach out after I continued to receive information from Weber and Aussie, they did not answer the phone or return any of the messages. So everything did clear on my end.
So, Your Honor, I mean, if she can provide me with a bank statement showing this cleared, that would get to the bottom of it. But I'm fairly certain there won't be one because, like I said, it didn't clear our system. The money never came into our system.
All right. So what I'm going to do is I'm going to adjourn this hearing. I'm going to send the two of you to a breakout room.
Sure.
You can discuss logistics as to how you can back up this payment and clear. And if it cleared, then that's the end of this case. If it didn't clear, then I will address that at the next hearing. Everything points in that direction, except Ms. Marshall, except that the attorney is saying that on their end of it is showing that the payment was made, but that it never cleared. So we got to figure out what happened along the way. So I'm going to go ahead and set this over for a meeting. But right now, I'm going to give the two of you an opportunity to discuss this in a breakout room, logistically what you will need to do from this point to try to get this worked out. So I'm going to set this over. Bring it back on June the 8th. June 8th at 9:30, 6/8 at 9:30 is when you'll come back to see me on this. Right now, I'm sending you to breakout room number 1.
Thanks, Judge.
You're getting a notification from me in that regard. I wish both of you well. Okay.
Thank you, Your Honor.
All right, the court calls case number 20, 168567. This is Ricard Mitchell versus Member Select Insurance Company. The matter is before me on an adjourned date of hearing regarding this matter. All right, your appearance for the plaintiff, this is set for review. Your appearance for the plaintiff in this matter.
Morning, Your Honor. James Eckleberry, P 78222, appearing on behalf of plaintiff Ricard Mitchell.
Thank you, Mr. Eckleberry, and good morning to you, sir. For the defendant, member select, please.
Good morning, Your Honor. Heather Thatcher on behalf of defendant member select P 83844.
Thank you, Ms. Thatcher, and good morning to you as well. I know that we dismissed nationwide out of this on the previous date. I sent it over for. Tell me what's going on here. Somebody update.
Your Honor, I'm happy to report we are settled. We settled the case this morning.
That's correct.
Okay. All right. Well, I won't impose myself on it any longer then. How about that?
Sounds good.
All right. I will note that the matter is settled. So somebody's getting an order in to me or?
Yes, Your Honor.
So I'll note that it's settled and that I'm awaiting an order. So get that to me right away and we'll get that all taken care of. All right. I wish the two of you well. Good day.
Thank you, Your Honor. You as well.
Thank you, Your Honor.
This is case number 21-169-886. This is Dynamic Medical Supply LLC versus City of Detroit. Looks like I called this previously. What's
Your Honor, this is actually identical to the John Betts case that was called earlier. It's the same patient, same issue. So that's why it sounds very familiar.
all right? Your appearance at this time is below for the record.
Good morning, Your Honor. James on behalf of the plaintiff. My P number is 63110.
All right, thank you, sir. I was looking at Shanika Hintz. I'm like, wait a minute, we just talked about that. All right, for the City of Detroit, if you will, your appearance, please.
Ben Patterson, P number 85118 for City of Detroit.
All right, thank you, Mr. Patterson, and good morning again to you, sir. All right, so what's going on here, if you will?
Your Honor, I see in my system that we had drafted a stip in order to bring in National General as was in the identical case that was called earlier. I don't know if the court has signed it yet, but and we have a First Amendment complaint drafted that includes them, but I don't know if the court has signed that order yet. If the court has, then we can file our amended complaint and bring National General in.
Yeah, that should be out to you in the mail. I did sign that order on the 6th of May.
Okay.
I'm looking now, so that is all taken care of. So looks like we're waiting for that party to be brought in, served, that kind of thing. Is that correct?
Yes, and now that we know that the order is signed, we'll file the amended complaint probably today.
Very well. So other than waiting on the next steps in this matter, anything that either party needs the court to address at this time?
Not for me, Your Honor.
All right. So did I already put in some kind of discovery order in this matter at all?
I believe, Your Honor, I think it's probably very similar to the prior matter. Discovery was to close today.
I do see that. Thank you. So I will extend the discovery date over, and I'll go ahead and set it. I'll go ahead and set it for the 8th of July. July 8th. We'll take another look at everything at that time. That should give some time for the new defendant to get into this matter and for an answer to be filed. We'll be able to make some judgment on the case. So that's going to be July 8th, and that's going to be at 9:45 a.m.
Your Honor, I'm sorry to do it, but I'm actually out on vacation that whole week. Would you mind putting it over to the following week?
And that's the one that's that I'm away. And so I'm getting some, so.
You could also put it on at the same time as the other, the other matter that is the same, which I believe you said was July 21.
Okay, yeah, let's do that. You know, let's do that. I don't have to work here today. And so when I gave that date, I was looking around. What date did I give on the other? So,
Yeah, July 21 and 9:45 is what you said for the other matter.
all right, that's where we're gonna put it. July 21st at 9:45 a.m. It'll be on the same date, same time, and we'll address these matters at that time. Discovery remains open through that date as well. And of course, the other party will be just coming in, so I'll take a look at discovery issues at that time as well.
That makes sense, Your Honor. Thank you.
Wish you all, gentlemen. We'll see you on the next action date.
Take care.
Thank you, Your Honor.
All right, let's do that.